Hi, I'm Gene Trowbridge with the law firm of Trowbridge Nieh. We're securities lawyers, and you're on our YouTube channel to watch the YouTube that I call 506B and 506C at the same time. Now, this is a new idea, and there's some relatively new information about this, and it all has to do with the concept that the SEC has always had, which is integration. So I want to share with you what's new, and this might be exciting for some of you who are looking to do deals and have thought about this question: can I do both a B and a C at the same time? So this is who I am, founding partner of our firm. I was a syndicator for a long time. Real estate broker, CCIM instructor for 40 years. I went to law school at 45 to take my syndication career into the legal world, and it's been a pretty exciting career for me. I'm the author of a book. It's called A Whole New Business, and you'll get a chance to receive a free PDF of that book at the end of this presentation. And my spare time, an old runner. I run half marathons, and as I get older, I get slower. So that's about me. The Integration Doctrine is a long-standing doctrine from the SEC. And here's what it says: is this doctrine seeks to prevent an issuer from improperly avoiding a registration. Let's stop right now. Every security needs to be registered unless it's exempt. So if you blow your exemption, you'll have to register it with the SEC. So this doctrine stops an issuer from improperly avoiding registration by artificially dividing a single offering into multiple offerings so that the exemptions that would apply to the multiple offerings would not be available for the combined offering. Generally, this means if you start a private offering, you must finish with a private offering. If you start under one exemption, you must finish under that exemption. So generally it means if you start under 506B, you end up under 506B. There's a couple exceptions to that. And if you start under 506C, you'll end under 506C. That's pretty much standard there. So the historic 5-factor test to determine the need to integrate is when two offerings appeared to the SEC to be part of a single financing plan. They both offered the same class of securities. The sale of those securities happened at about the same time. The pricing for those securities was the same, and the proceeds of two offerings were actually used for the same general purpose. Now, in Regulation D, what we have is we have two types of offerings, 506B and 506C. The difference between these offerings is in 506B, there's no advertising and solicitation, and you can take 35 sophisticated investors. That rule was put into place to provide positive impetus for capital formation. 506C, the basic rule is you can advertise and solicit to find people to invest with you, but you cannot have sophisticated investors. So the real key here is in 506B, you have to have a pre-existing relationship with your investors because there's no advertising. 506C, you do not need a pre-existing relationship because you can advertise. So one of the things that's been happening for a while is we can do an offering that starts in a 506B, no advertising, you're taking all the investors in, you can, that you know, with your pre-existing relationship, and then we can stop that offering at that point and continue on with that offering under 506C. So when we stop and continue on, we can start advertising. From then on, when you're advertising, we can't have any sophisticated investors. Everyone has to be accredited, and we probably need some third-party verification to be reasonably assured that they are accredited, since we don't know them. Well, that's generally what's been happening. But now what this topic is all about is, could I come to the market with an offering that's 506B and an offering that's 506C at the same time, two separate offerings, and not have those offerings integrated? And the problem with integration is, if they put these two offerings together, the integration rule says we would apply the most stringent, the most restrictive rule. So if you put both offerings together, the most restrictive rule is no advertising and solicitation. And if you are advertising, you're going to lose your exemption. So you're going to have to register. So we need some protection in that. And that's what's new about this. Let's see here. In 2020, the SEC passed a rule, and they used the words harmonization, and it was all designed to help people with this integration rule, and to help them make offerings and understand what they can and can't do. And the rule is that offers and sales will not be integrated if, based on the facts and circumstances, if an exemption from the registration is available for each offering. So basically what they're saying, if you're doing a 506B, you don't have any offering advertising, your pre-existing substantive relations with all your investors in that offering itself will be exempt. And at the same time, if you're doing a 506C offering where you can advertise, not take any sophisticated investors, and do third-party verification to be reasonably assured your investors are accredited, if you do that, that offering will be exempt. Now you have two exempt offerings going on at the same time, and they won't be integrated. So this is regular. This is kind of new. Even though it was in 2020, there's been a lot of conversation about this. And the rule that if we researched, we found was Rule 152. And what it says is issuers may conduct concurrent 506C and 506B offerings, so long as the rules related to pre-existing substantive relation for the 506B offering prohibiting general solicitation are allowed. So the real key, if you're going to do two of these at once and you want them both to be exempt from registration, is make sure that the 506B is following the specific rules on pre-existing relationships. Then there's another thing that they added. There was a period of time when, if you closed one offering, no matter what it was, and you open the next offering more than 90 days apart, you would not have your offerings integrated. Well, they shortened that rule. What they really would like to do is allow a sponsor to raise money every month. So now the rule is any offering made more than 30 days before the start of another or after the finish of another offering will not be integrated. So there's this 30-day time. If that's the rule you want to have, they won't be integrated, and that's pretty popular. It says this safe harbor cannot be used to circumvent the prohibition on general solicitation. What they're saying is, if you blow the rule because you've used general solicitation inside of a 506B, waiting 30 days, if you had waited 30 days to start this offering, that won't work. If you blow the general solicitation and blow the issue of pre-existing substantive relations, you're going to lose your exemption, and your offering is going to have to be registered. And if you don't, you lose your exemption, you can be charged with selling unregistered securities, which is not good at all. So the answer to the question is yes, according to the rules today, you can do a 506B and a 506C as long as you follow the rules. In addition to being able to do a 506B that converts to 506C. I would suggest that your two offerings cover different products. One of the things that used to happen is someone would do an offering to buy the dirt and then do another offering to raise the money necessary to build the building on the dirt. Same project, same price, same financing. But what they wanted to do is they wanted to exceed the 35 investor limit by putting two offerings together that both have 35 investors. Well, you could do that now if you follow the 30-day rule, okay? But if one of your offerings is 506C and one is 506B, you can do them at the same time. So I have a book, and I'd like you all to get a free copy, free PDF of my book. And there's the website, book.tnllp.com. Go right there and we'll get you a free PDF of my book. And in the book, I have a number of topics we discuss. We discuss entities, including tenants in common, which is popular today. We talk about the securities laws. This book is the 4th edition, and this is the 4th time the securities laws have changed since I wrote the 1st edition. That's what prompts me to write a new edition, is a change in the securities laws. So we go through all those topics in the book, and you're welcome to come to the website and have that. And when you're at the website, make sure you subscribe to our YouTube channel and get all the other good and timely information we post there. So this is Gene Trowbridge saying, we'll see you next time.